Hello, everyone, and welcome to Uncivil Law. For today's segment, we have Stupid Letter Time. This is a letter from the Congress of the United States, and perhaps a hopeful sign in our trying, divided times. This is not only bicameral in that it has both members of Senate and representatives, but it's also bipartisan. We've got both Republicans and Democrats together. So both members of the House and Senate, both Republicans and Democrats, have come together for Stupid Letter Time. So we're going to read this letter. In today's edition of Stupid Letter Time, several members of Congress are writing the American Law Institute about a restatement of the law that they're writing. The American Law Institute is perhaps one of the more notable groups that does this. Their word is considered to be pretty good. They're relied on. I read them. They're a very good summary of the law. And, they're not authoritative. They're a private organization, but they're respected and trusted. And the American Law Institute wants to write a restatement or a treatise or a retelling, if you like, of the copyright law. They want to provide a summary of the copyright law. But members of Congress are unhappy with how American Law Institute is writing their summary. So let's read their complaint and mock this in the latest edition of Stupid Letter Time. Let's get started. From the United States Congress of Representatives, dated December 3rd, 2019, even in the height of the impeachment inquiry, bipartisan bicameral action. To the Director of the American Law Institute, Mr. Rivas. Dear Director Rivas, we write today regarding efforts of the American Law Institute to develop a retelling of copyright. It has come to our attention that the first 18 sections of the proposed copyright restatement were considered for approval by the ALI Council in mid-October, and 2 of the sections were approved. Those 2 sections and any other sections that are subsequently approved by the Council that are then considered by the full ALI membership and if approved by the full membership will be made publicly available and then may be cited by federal courts. Yes, that's kind of how these things happen. There's different versions of it. Some of it are just written by a guy. For example, one of the best restatements on patent law is written by a guy. His name is Chisholm. It's Chisholm on patents. It's a guy. He writes a very good restatement. American Law Institute is an organization, so they have a more bureaucratic structure. They proposed a bunch of these, and yes, they may and will be cited because people trust ALI because they do good work. Let's read on. ALI is a respected organization whose restatements are often cited as highly persuasive authority in court cases and scholarly works. Very true. Traditionally, restatements have focused almost exclusively on areas of common law because judicial rulings across different jurisdictions may vary, and ALI's interpretations are predisposed to assembly, analysis, and summaries. That's not really true as far as I'm concerned. As I was saying a moment ago, one of the greatest restatements about copyright law is written by a guy. His name is Chisholm. It's a Chisholm on patents. It's about patent law, which is common law. And of course, Chisholm on patents is not alone in this respect. When it comes to the other domains, there is Nimmer on copyright and Landis on trademarks. They're basically all written by guys, and they are not on common law. They're widely cited, considered authoritative. So, okay, let's carry on. By contrast, laws created through federal statute, including a federal copyright law, are ill-suited for treatment in a restatement because the law is clearly articulated by Congress in both the statute and legislative history. The many courts decisions that deal with federal law would tend to disagree with you. We have an entire federal court system to deal with federal law. We have entire groups and organizations that do nothing but federal law. So the clarity of the federal law leaves a lot to be desired, at least in the opinion of, the courts that you've created to try to interpret the federal law and the disagreements they come to. So not quite sure your conclusion that follows there, guys. In creating legislation, Congress develops legislative histories through hearing testimony and committee reports. Legislation is then expertly interpreted by agencies. No. Are we going to have a discussion about Chevron now? I was so excited. Now we're going to have to talk about Chevron, aren't we? Oh my Lord. Legislation is then expertly interpreted by agencies charged with that authority by Congress, such as the U.S. Copyright Office and the U.S. Patent and Trademark Office. I'd also take a view as to whether or not the United States Copyright Office actually qualifies as an agency or not, because it's part of the legislative branch. So I'm not sure whether or not it legally qualifies as an agency, but let's carry on. The ALI has long recognized that federal statutes do not require a restatement and are thus not an appropriate platform to effect changes in federal law. So we want to branch out and do other stuff. Okay. There are restatements on federal law, you know. We want to write one. Okay. What's the problem? Throughout its almost 100 years of existence, the ALI has never chosen to draft a restatement of area of law that's almost exclusively federal statutory law until now. Yes, and because we've never ever done it in 100 years, we have to get permission to do it now because reasons. We are deeply concerned by ALI's current copyright restatement project. Ooh. In fact, any restatement or other treatise relied on by the courts that attempts to diminish the importance of statutory text or legislative history relating to that text would warrant concern. Such as, for example, Nimmer on copyrights, or Landis on trademarks, or Chisholm on patents, those kind of things. Courts have used them before, seem to be fine, not quite sure what the problem is. Courts should rely on that statutory text and legislative history, not restatements that attempt to replace the statutory language and legislative history established by Congress with novel interpretations. Such as, by example, the novel interpretations come up by the courts that Congress also established. We are not the first to raise these concerns with ALI. The U.S. Copyright Office, the preeminent expert within the federal government on issues relating to copyright law, and God save us all for that, has shared its concerns relating to the copyright restatement project with ALI. Thank you for your note, I guess. But when we're finished with it, we're still going to send it to the Copyright Office for copyright registration, so you can look forward to that. One of the statutory duties of the Register of Copyrights is to advise Congress on national and international issues relating to copyrights, other matters arising under this title, and related matters. As advisors to Congress and experts in the area, we value the Register's input and share her concerns. You do understand that, like, other people can also talk to you about these issues. Like, the Copyright Office has knowledge, but, like, other people have knowledge and opinions that may differ from those. Deep thoughts. The fact that similar concerns were raised by other copyright experts, including the United States Patent and Trademark Office, which, you know, incidentally, they do actually have copyright people inside their office, despite not doing that. They do actually advise on that issue, so that's not, like, as far afield as you might think. The American Bar Association, the IP Law Section, and numerous academics and federal judges further demonstrates to us the seriousness of the concerns relating to the project. Well, either the restatement of the law is going to be good or it's not. Either courts will use it or they won't. Like, you know, courts don't have to use it. People don't have to cite it. It's not God. It's just here's a summary of what's happened. Does Congress not understand how restatements work? Basically, it's just here's a summary of everything that's ever happened in this case, just so, like, you know, the history of the law and the history of the cases. Basically puts it all in one place. It's really, really convenient for lawyers, by the way. It's super, super convenient because it gives you, like, a summary of everything in one place, and unless you, like, figure out where to start looking. So treatises are great. Use them all the time. So, like, I'm not really sure I see the problem. We also understand that the American law institution has come under some scrutiny relating to other controversial projects. The late Justice Antonin Scalia, who was the most frequent author of opinions citing ALI publications in 9 opinions, wrote that modern restatements are of questionable value and must be used with caution. Great. They're questionable value and use them with caution. Great. They're not the law. They are restatements, retellings of the law. So use them for the value they have, or don't. He added that over time, the restatement's authors have abandoned the mission of describing the law and have chosen instead to set forth their aspirations for what the law ought to be. Well, that's one thing you might do, especially in terms of, like, forecasting where you think the law might be going. So you say, like, well, here's some things that we're taking note of, and here's where it seems to be, like, where the law is going or where it could go. So, like, that might be a valid exercise, and, like, a court can, of course, ignore it because it's not the law. In his dissent in Kansas versus Nebraska, Justice Scalia stated that newer restatements should be given no weight whatsoever as to the current state of the law, and no more weight regarding what law ought to be than the recommendations of any respected lawyer and scholar. Okay, I don't disagree with him. That's fine. They are no more authoritative as to what the law should be than anyone who's really knowledgeable about it. Fine. What's the problem? Lately, many states have also begun to repudiate the more recent and controversial restatement projects, such as insurance liability restatement. Arkansas, Michigan, North Dakota, Ohio, Tennessee, and Texas have all recently passed legislation that in some form seeks to curtail or even condemn the use of insurance liability restatement under their respective insurance laws. Well, that's fine. I mean, the state is the authority as to what its law is. They're the one that writes it. If they say, well, we don't think this treatise is very good or authoritative, or we don't think it's good and should be used, then okay, that's a valid opinion. The Kentucky and legislatures have also passed resolutions stating their opposition to the restatement. Since copyright law is predominantly federal law codified at Title 17, it would be Congress and not the states that would take action in this case. By sending this letter today, we're hoping that you will address our concerns with the Copyright Restatement Project. Given the significance of this issue and the importance of the copyright law to this country's economy and culture, we respectfully request your response to the following questions. They also act like these groups are not part of the restatement project itself. Like the people they're talking about in the Copyright Office are members of ALI. They are participating. They've been invited to participate. ALI wants their participation. So like these people have been there. The ALI has gotten everyone in this thing. They've gotten copyright maximalists on board. They got the Copyright Office on board. They got minimalists on board. They got everyone on board because they want to be a good restatement of law. They got a whole bunch of perspectives in a mix. And now they're writing like the combined conclusion of all these people to be hopefully something that's more or less correct. So like, it's not like they've been ignoring these people. These people are members of ALI. These people have been participating heavily in this project. What are you talking about? Question 1. The ALI has been in existence for close to 100 years. The federal copyright law has been in existence for more than twice as long. Why has ALI chosen to draft a restatement of copyright law now? What change in the law or in ALI's mission or scope necessitates taking on every project? I think necessitates is the wrong word. Nothing necessitates it. We thought it'd be good to do, I'm guessing. Question 2. How are the ALI and the reporters approaching this complex federal statute like copyright law? Oh yes, the ALI doesn't know how to deal with complexity because they are not used to like figuring out what the common law is for all 50 states, and that massive nightmare. So yeah, this is so outside their wheelhouse. Yeesh. Does that approach differ from the approach it usually takes in restatements that focus on common law? Probably not. How is ALI purporting to restate a federal statute? Probably by like quoting opinions that have interpreted it would be, and major law reviews and major treatises and other things that like bring everything together for people to have a very good understanding of the law. So that'd be good. Here's a whole bunch of things that you can look up. That's what they kind of do. Question 3. When drafting the copyright restatement, how much weight do the reporters and ALI counsel give to statutory text and legislative history? Presumably, some. Question 4. When there's a discrepancy in the interpretation of copyright law, how do reporters decide on one position to take over another? Through debate and consensus, they have panels that argue these things out, that argue and debate, and then you kind of actually answered this question earlier above when you said the process they went through, like how it gets adopted by committees and then by ALI and then by the membership. There's a multi-step process. So you kind of know that. Do they consider the statutory text? Yes. Probably it's kind of relevant. Do they consider legislative history? Yes. Are the views of the Copyright Office experts given greater weight than the views of others? Not more authoritative than the courts? Probably no. To what extent does the proposed draft give deference to the Copyright Office's interpretation of the Copyright Act? Well, if it were me, not as much as the courts do, because Chevron needs to die. Could an expert from the Copyright Office be chosen as a reporter? Sure. In fact, they have been, as a matter of fact, and you would know that if you're paying attention. When there are gaps in the statutory or case law, hey, that's one of the things that sometimes these things do. That's one of the things they do is to fill in gaps. Yeah, because you're not writing perfect laws after all. There are, in fact, gaps. So, yeah. How do the reporters decide when to fill in those gaps as opposed to decline to take a position? Again, debate, consensus, looking to what other people have said, so forth and so on. Copyright law is constantly changing. Oh, yes, as opposed to like the rest of the law they have to deal with. In fact, just last year, Congress passed the Music Modernization Act. And this year, Congress is considering other copyright-related bills. The Copyright Alternative Small Claim Act. How will LAL deal with these changes? Probably by adding pages to the restatement. Question 7. The U.S. Copyright Office raised several concerns in its January 2018 letter, along with a number of other letters sent to ALI. Has the ALI formally considered these? How are they addressing it? Debate, consensus. How does ALI address potential conflicts of interest? What's the potential conflicts of interest, for example, like those of the Copyright Office itself? That doesn't comprise a conflict of interest, right? The Copyright Office being asked to interpret the copyright law, that wouldn't comprise a conflict of interest, right? The Copyright Office would have no reason to say the copyright law is great and super wonderful and there's no problems with it ever. That's not a conflict of interest. That's not the conflict of interest you're talking about, right? Yeesh. What steps does ALI take to prevent bias from affecting the proposed draft? Well, they've invited the Copyright Office in, and you're actually asking them to take more bias in. You're the ones asking them to be even more biased. You're the ones saying, just look at all law. Just look at what the Copyright Office is. Do you want them to be biased or unbiased? Pick a side. Number 9, will ALI attempt to restate other federal laws, such as patent law in the future? Probably. That's fine. If it's a good restatement, I'll use it. If not, I'm not. You know, the books that are out there are fine, but if they want to come up with a new one, maybe it's good. That'd be great. We ask that you respond to this letter with answers to these concerns by January 3rd. Or what? Wait a second. Yeah, I just wanted to double check. I just wanted to make sure that I wasn't reading an old letter. So the letter is to say it's December the 3rd, January 2019. And then they say, we ask that you respond to this letter by January 3rd, 2019. Well, I don't know how I'm going to respond to something that occurred 12 months in the past, but I'll give it a go. Do you guys have a time machine, or do I talk to the patent office about that? Thank you for advance for your answers to our questions and for responding to our questions. If you have any concerns, please do not hesitate to contact us. Sincerely, Stupid Letter People. So that is the end of the current edition of Stupid Letter Time. In our current edition of Stupid Letter Time, we learned several members of Congress wrote ALI to tell them to not do their job and not write restatements because they're not writing what they want them to write, and it's very, very bad for some reason. So I would suggest Congress should get over themselves. ALI should keep doing what they're doing. ALI does go to work. If it's a bad treatise, we'll ignore it. It'll be fine. Other treatises do exist. It's not that big a deal. And that is the end of this story.